Okay, so just a quick recap. We have so far discussed commencement of proceedings, and we noted that from the manual, we are required to understand the various means of commencing civil actions. We'll be discussing that. And then we are also supposed to know when each mode is appropriate. One will use a writ instead of originating motion or originating notice of motion, or one will use a petition. Then we are also supposed to discuss when it comes to writ, which is our main concern, we are supposed to know the technical and the substantive requirements of a writ of summons. We discussed that extensively in our previous classes, and we look at a writ, and we decided to do ocular or visual examination of the typical requirements of a writ, because we noted that a writ has got some technical features, and those should be appreciated. So we explain what they are, and we were supposed to have started discussing the proper venue for commencing an action and transfer as the case may be. And then that is where we actually break off. But before we continue from the venue and then we continue with the parties and joinder, if anything is not clear to you regarding the first aspect, that is the modes of commencing proceedings generally, you look at if you like the three, if you like a main modes. So if you still have any question, please, you raise up your hand, and then I will address it before we move on, because civil procedure is a lot. So if you are not clear, you keep quiet and say that, okay, we come back to it. We may never come back to it until maybe a week of a revision or 2 weeks of revision before you do the exams. Okay, so I presume that we are all, okay, Frank hand is up. Frank, the host, Eric, release Frank. Yeah, okay, Frank, go ahead.
Good evening, my lord.
Good evening.
Please, my question is about writs. I've seen that sometimes the name of the plaintiff will be clearly spelled out, but the defendant, they will put something like a developer or trespasser. So I don't know. I want to know situations.
Okay, good. Yeah, that is a good observation, Frank. Now, having a developer or trespasser is a new development. It's actually the Land Act of 2020, Act 1036, which introduced that possibility. Before the Land Act, you needed all the time to know exactly who your defendant is. But if you look at the Land Act 1036, it makes possible that in some situations, if you are suing and you don't know who is trespassing or who is occupying a particular land, you could just do that. And the court will even allow a substituted service to be posted on the particular land. Yeah, so you are right. But that is, as I said, it's a new thing. It is made possible by the Land Act 2020, Act 1036, as it were. So if you remember your land law, I'm sure you have been told this new addition introduced by the Land Act. But also, apart from that, in all other situations, you must actually specify who your defendant is. And that is why I am an associate. So if you bring a writ to come and serve of me, and then it bears the name, let's say, Kwaku Mensa. Kwaku Mensa, I am not the one. But if it's an SOSUDAPA, I cannot, ignore it, as it were. And don't forget, when it comes to res judicata, we talk about this. Res judicata. If, for example, in future, you are going to litigate, and then you need to be confronted with the fact that you cannot litigate this again because a court of competent jurisdiction has already pronounced upon it. And there was a case either involving you and another party or someone that you derive title from, or your successor in title. And for that matter, you are estoppel per res judicata or res judicata simpliciter. And that is why the name of your defendant is important. But for the, in the case of the Land Act, permitting that you can sue, if you like, a developer or trespasser, we can easily understand it because cases involving land is, if you get a judgment, it's a judgment in rem. Judgment in rem in the sense that it's a judgment which binds the whole world as far as that particular parcel of land is concerned. So if there's a land at the Makula campus, okay, and a declaration is made that it's for you, Nanapoku, if somebody in the United States, somebody in South Africa, he will have to respect that because the judgment is in rem, is not in personam. I don't know if that assists you. Yes. The question now, are you?
Yes, my lord. Yes, I'm fine.
Right.
Thank you.
All right, thank you. Yes. Good. So with respect to rates, we made the point that it is issued by the registry under seal. And we explained that if the lawyer or a party drafts a writ, and is not taken to the registry for the registry to put the seal on it, it is not considered as issued. And we also noted that the writ is a command to the defendant to enter appearance within 8 days. If you look at the forms which have been provided at the back of CI 47, we have, I think, Form 1, which is supposed to be the template, as it were, for a writ. And we made the point that previously, litigants will have to actually buy the writ from the registry, but because of advancement of word processor or writing technology, lawyers have a short version and they will just print it and take it there for the registrar to put the seal on it. So let's note that. And then we made the other point that as a default rule, all actions are commenced by writ unless otherwise stipulated by an enactment. So if an enactment has not indicated that this should be by application or by petition, the default mode is what? It's a writ. I want us to get this, and I want it to sink in very well as we proceed. Now, in terms of drafting a writ, we noted that Order 2, which provides the specifics, says that we have to always indicate the nature of the claim. What exactly are we asking from the defendant, the nature of the claim? So what we call the statement of the nature of the claim. And I have told you before that statement of the nature of the claim required by Order 2 is different from statement of claim as a pleadings, okay? We have like a statement of claim as a pleading, which we will come and discuss pretty soon. But when we are dealing with the writ and we talk about statement of the nature of the claim, we are talking about a prayer, the relief or the remedy which you are asking the court to grant you, as it were. And again, we indicated that residential and then the occupational address should be provided. And where you are looking for a particular amount of money, which what they call the liquidated claim. Later on, we are discussing appearance, especially judgment in default of appearance. We will explain this more. But you remember your contract, Dunlop pneumatic tie and suffrage, a liquidated claim amount of money which is ascertained by the parties. So if you are suing somebody actually for amount of money, if you are suing somebody for amount of money, which that would be like a liquidated claim, as it were. But as I said, when we are discussing judgment in default of appearance, we'll see more about this. So let's keep that in mind. Now, the gentleman who asked the question that can you bring an action against an unidentified defendant, like a trespasser or squatter, occupier of a land? I'm sure that you might have had at the back of your mind statements of observation made in discussion of civil procedure that you cannot issue a writ against a faceless defendant. That is the general rule, that you cannot issue a writ against a faceless defendant. But there's an exception, and the exception is what I have told you, that it is permissible under the Land Act now to be able to sue just an occupier of a land. Let's look at this practically. You have a land at Adenta, and you go home, you come back and you see that people are building on it. So just as you got your lawyer to get the processes done, go to court and get a writ issued, you come back, there's nobody there. You go back and then you return. You notice that work is being done, but there's nobody there. Can't you sue? You don't know the defendant, but somebody is obviously trespassing. And that is why there's a wisdom in what the new law says, that the court will allow you to bring an action against an otherwise faceless defendant. So let us keep in mind. Then we also indicated that you need to indicate the capacity. You need to have endorsement as a capacity. So we talk about Order 2 reform. And we said that if you are suing in representative capacity, for example, you must indicate it so that we know the local standard, we know the standing, the capacity in which you are in court. If you are seen as a head of family, it should be indicated. Are you administrator or executor? It should be indicated. Trustee, or you are guardian ad litem, that is a next friend of a minor. It should be indicated. Yeah, so we cited a number of cases which tells us that where, of course, previously, let me add, previously, the position of the law used to be that if you don't endorse the capacity on the rate, then it is fatal. But the current thinking from various Supreme Court decisions, including the National Investment Bank, again, the Standard Bank Offshore Trust Limited, and there's a thinking that because now the rate is accompanied by the statement of claim, if, for example, the statement of claim clarifies the capacity in which the party has sued, of course, a bit similar to what we read in the case of Ghana registered Muslim Association against the Salif, then that will not be fatal, because unlike LN 148, the old civil procedure rules, in the past, you will get a rate issued and later on you get a statement of claim. But now, as we learned the last time, that the rate must be accompanied by the statement of claim. And the Supreme Court takes the view that even where there are some defects on the rate, but then if we put it in the context of the statement of claim, and the statement of claim actually provide what is apparently lacking in the rate, you cannot, and now under the doctrine of substantial justice, you cannot just declare the action as as nullity or as void, because the rate and the statement of claim is read together. It is only where the two are considered and we are still not seeing our way clear regarding what is at stake before you suffer the consequences of the law, as it were. Again, we also noted that where you are suing by a lawyer, it must be indicated that it is issued by a lawyer. And of course, the lawyer's license. We mentioned the case of ex parte Teriwaja, that the lawyer's license must be indicated. And the lawyer's license also goes with the chamber's license, because under the Legal Profession Act, if you must be licensed to practice law, and you must also practice from an accredited or licensed law firm. So we noted that. And that rule has been quite harsh. You've had the cases where a whole writ was declared a nullity because it's signed by a lawyer on behalf of a litigant, a lawyer whose license has expired or who does not have a license in the current year of practice. It appears harsh, but that bar will tell us that where the Act of Parliament has provided that something should be done as a precondition, no judge has the authority to grant an immunity. So either if you are acting by a lawyer, either the lawyer is licensed or he's not licensed. There's no middle position. It's different if you got the writ signed by yourself, as it were. Then because we have noted from other two that the writ must be accompanied by statement of claim. If it's not accompanied by statement of claim, it's not valid, so it's prohibited. So let's take note of that. Then we also talk about concurrent writ at our last meeting. And we said that a concurrent writ is where the writ is issued and the party requests that the same writ should be issued with a concurrent on it. And then you may want to ask, why will a party ask for a writ which has been issued to be issued again, like within the same time period? Because as we noted last time, the duration for a writ is 12 months from the date of issue up to the 31st day of that particular calendar month, as it were. Now, we explained that it may well be that the writ was a writ issued in Ghana, notice of which is to be served outside the jurisdiction. So you may want to get one ready so that whenever you cite or you spot the you cite or you spot the particular defendant as having come to Ghana or something, you will just proceed and get it served on him. So that was the reason why we said that a party may, for example, want a concurrent writ to be issued. So let's keep that in mind. And again, it can also be done in Ghana. Maybe, mind you, the writ will have assuming you have the date, you have the address of the defendant, which you are supposed to, if you know it. And you say that it's going to be served on the defendant who is in Kumasi. Now you want the same writ to also be served on you are not sure whether the defendant is really in Kumasi. Maybe the defendant is in Takoradi or in Tamale. And just out of abundance of caution, you can ask the registrar to issue a duplicate of that writ. In the same respect, everything is the same. Because the only thing is that the word concurrent will be embossed or write on it. And once you have that, wherever you find the defendant, you get it served on him. But then somebody asks a question. In view of the possibility of photocopy, why would a person needs a writ, concurrent writ? Because after all, if you have one issue, can't you just run a photocopy and use it to serve the defendant wherever? And I made the point that that is right, but we have to put the concurrent in context. It has a historical background. Mind you, we said that it should have the seal of the part of the registrar. Okay, so you can get a person who is served and who say that, well, what he sees is not the seal, so this is fake, it's not authentic, and he decides to, for example, ignore it. The law says that it should be a seal. So if the person has, for example, ignored it, and if he can put up a good defense later on, if you decide, assuming you got the judgment in default of appearance because he decided to ignore it, and later on you decide to levy execution, then you come and say that, well, I'm a stranger to this judgment, and this judgment cannot be enforced against me. And part of this argument will be that, as far as it's concerned, it's never been served with any valid writ of summons. So the one who asked a question, whether photocopy will not suffice, I think this is part of the reason. I don't know if the person is here. Is the person here? Yes, Michael Aban.
Yeah, hello, my lord. Good
Yes.
evening.
Good evening.
Yeah, and thanks for the opportunity. I'm not the one who asked that question, but I was just about asking a question in relation to that, and then you went straight into answering that. Do I take it or understand it to be like the certified true copy in a way?
Yes, certified true copy is also there, but usually, yes, it will serve the same purpose, but it's not the same. Because certified true copy will just have certified true copy put on it. But the concurrent writ will have concurrent written on it. And as I said, in modern times, it does not look, it doesn't look very or doesn't appear convincing, or doesn't look sensible. Let me put it that way, because of the various possibilities out there. But in the past, it was very important, and especially, as I said, if you are dealing with a very controversial litigant who will say that, well, a writ must have the seal of the registrar. If if it is true, I will submit to the jurisdiction of the court. If it is not, I just ignore it. That is probably part of the reason why in the past it was not just stated like a certified true copy. Yes, I think somebody has put something in the chat. Are you still asking the question, or is taken care of so that I move on? Let me see. Yes, a user, what is the question? The one who put it, yes. Are you the same person?
This is Edward, my lord.
All right, Edward.
Yes. So last week I asked the question whether or not we cannot use the writ to serve in another region. I think I started the question, then there was a follow-up as to the photocopying.
Okay.
Now I just want to know the concurrent writ. Can the plaintiff himself serve the concurrent writ, or it has always been the bailiff who can serve the writ, the concurrent writ?
Oh, okay. All right. We'll come and discuss service, but once you ask a question, we provide immediate response before we give a detailed discussion of it when we are discussing that particular topic. Good. As a rule, we have a process server, who like the bailiff, an agent or a subordinate of the registrar of the court. So he or she is supposed to serve the writ because they have what we call like a proof of service. There should be someone who in law is given the authority to certify that, yes, I can confirm that the writ has been served on XYZ. So if you look at it, I think last time someone asked a question, what about if you don't know the address? Can't you just say, lawyers, you write plaintiff to direct service, like plaintiff to direct service, for example. So in which case you are saying that you don't know where the defendant is, but you are prepared to direct service. Let me just show you one example. So if you look at this, for example, so let's say, look at this. Of course, the plaintiff with direct service here really apply to the second defendant. But for the first defendant, Standard Chartered Bank, everybody know where it is and it can be located. Yeah, so if you say the plaintiff with direct service, but it doesn't mean that the plaintiff will prove service. It is the bailiff who have to prove that there has been a valid service. Unless the court, sometimes when it comes to substituted service, especially now that the court is able to give an order for substituted service by means of WhatsApp or some other social media platform of communication, the court can sometimes say that you're supposed to file affidavit of due service. That one is an exception, in which case the court is directing a party to indicate that a particular process has been served according to how the court directed. But that is the exception. It's not the norm, or it's not like the general rule. So let's keep that in mind. Then we finally also made the point that a writ has a duration of what? 12 months. And what that means, we cited a couple of cases. What that means is that if the writ is not served within 12 months, the writ expires. However, it is possible for it to be renewed either before or after its expiry. And we noted that under Order 2, Rule 9 of CR 47, you would need to go by motion to actually explain to the court why the writ expire and you not being able to serve it as it were. And we also noted that where a writ has expired and you go and renew it, assuming the particular underlying case, the cause of action, is, for example, caught by limitation of actions, in which case it is statute barred. The mere fact that you have succeeded in getting the court to renew the writ for you, pursuant to Order 2, Rule 9 of CI 47, as we have said, will not necessarily resurrect a cause of action which has become statute barred, in the sense that limitation of actions has actually caught up with it. So let's keep that in mind. So renewal of a writ is not a backdoor to resurrect a cause of action which is statute barred. Let's keep that in mind. So let's give example. Let's suppose that under Section 10, you have a land action, 12 years, become statute barred, as it were, adverse possession and all that. So you have, let's suppose that you've waited and that has actually caught up with you, and you had a rate 2 which was issued, and the rate became expired, and you try to get the renewal, and you think that because the rate has been renewed, then the action has been resurrected. No. Then someone also asked the question, how does it work out? Is it let's say the limitation of actions, does it operate when you have served the party or when you have invoked the jurisdiction of the court? We answered that it is not when you have served the party, it is when you have invoked the jurisdiction of the court. The reason being that if I have a case against you, I go to court, there's no guarantee that I will succeed in getting you served today or tomorrow. And sometimes, after many trials, I have to come back to court and get another for substituted or service. But in terms of making a determination as to whether I have slept on my right or I have not slept on my right, as to whether the statute of limitation has kicked in or not, or whether the equitable mechanisms of equity aids the vigilant and not the indolent, whether it applies, is referable to when I actually cause the rate to be issued by the registrar and not when it was actually served. So let's get that in mind. And of course, if it were to be the other way around, the law will become an instrument for injustice, particularly so when you don't control the whereabouts of the defendant. Now, before we continue to the venue, the other quick thing we need to remember is that where there are certain condition precedents which you have to satisfy before you can sue, and I want you to pay attention to this very well. When I finish, I will post an outline of notes and then the case list through your prefect to be shared with you. Now, there are certain type of cases in which you need to satisfy certain conditions precedent before you can initiate those cases, before you can commence action. Let me tell you this. I had a similar one, but not exactly. But I had my baptism of fire as a young lawyer, I think in 2005. I had finished, I became a barrister. I'd gone to England to do my master's and come back. And I decided to start practicing in Kumasi. And I was doing the case with a very old lawyer, the late D.M. Medusei. And then the case involved the CRC unit committee. And I had not. And I'm sharing this bitter experience with you so that you open your eyes all the time. I had not actually adverted my mind to the fact that under the Local Government Act, it is the District Assembly which has the capacity to sue and be sued, and not a unit committee or any of the subdivisions under it. Now, the case I was doing, I didn't initiate it, but it's still not excuse for me, because if you're a lawyer and you get a brief, it's not excuse for you to say that I'm not the one who started it. You're supposed to do your situation assessment. You're supposed to do your legal audit to find out what might have gone wrong by the old lawyer who started it and what needs to be done in order to cure any anomalies. If you don't do that and you go to court and you get stuck, you don't blame the old lawyer. You take the responsibility because you didn't do your work. So I will not blame the old lawyer. Good. So it went to the court, and the court, I think it was some injunction about a land, somebody's land. The person said Joseph Bisa's Unit Committee was trying to use as a market, as a market, which is the person's land. So when the matter came up, the injunction was being sought, and this old lawyer took a preliminary objection that under the law, the plaintiff have brought to court is not a proper plaintiff, cannot be sued. And we argue. He was right. The law was quite clear. So the action was actually thrown out. So I'm just saying this to remind you that there are certain types of actions or cases in which certain condition precedents must be adhered to. Otherwise, whatever you're doing will be an exercise in futility, and it will be a nullity. Let me give you an example. If you want to sue the state, for example, you have an action against the state, against the Attorney General, in terms of Article 8 or any, however you sue like the state. If you look at the State Proceedings Act of 1998 at 555, Section 10 thereof requires that you give notice to the state through the Attorney General before you commence the action. So notice of intention to commence what? An action. You need to do that before you commence. The rationale for that, of course, we can give a number of reasons, but first of all, to enable the state, if the state consider it necessary, to explore alternative dispute resolution mechanism with you, get a settlement. And two, to enable the Attorney General is the nominal party and also defender of the state in all manner of actions, to enable the principal legal advisor and the nominal defender of the state to become aware, to be able to keep track. And that is the wisdom behind all these provisions. Of course, when you learned your substantive law, you have been told that in the past, there was what they called the requirement for fiat. Going back to English law, if you wanted to sue the Crown, that is, wanted to bring a suit against the government in the United Kingdom, you needed what they call the royal fiat. That is approval by the kingdom, by the state, that you can actually bring an action against it. But here in Ghana, by reason of our constitutional democracy, Article 88 and then the State Proceedings Act actually make it clear that those things are not needed. And also, if you look at the Constitution, it says that the state can sue and be sued like any normal person or entity. But Section 10 requires that you must give a notice. So let's keep that in mind. And again, you must also give a notice to assemblies. If you look at the Local Governance Act 2016 at 936, Section 210 requires that if you are going to bring an action against the district assemblies, metropolitan assembly, municipal assemblies, you must serve notice on them first. Again, if you want to bring, let's say that an action, like let's say a lawyer under the Legal Professions Act, you want to sue somebody to recover your legal fee. It is a requirement of the Legal Profession Act that you must have served a bail of fees, okay? A bail of fees, notice of bail of fees on the client or the prospective defendant. So look at cases like Ayana against Ajimai. Yeah, I'll give the list to you, so don't worry. Nate against Gaite, and then Gaisis Wenes against Lord Cass Crocklin. Amata Few against Suwa. So all these cases suggest that where certain condition precedents, such as notice or certain things are supposed to be done according to particular legislation before you can mount an action, if you don't do that, you are going to find your action being considered a nullity, so that it does not properly invoke the jurisdiction of the court. If the condition precedent are not satisfied, the court jurisdiction is not invoked, and the court cannot exercise jurisdiction because the law has laid down certain preconditions. So please, let us always keep that in mind. Because failure to comply with such condition precedents will render the suit incompetent. And mind you, you don't run to Order 81. Order 81 of CF 47, and you don't write to expire to Orgate, because Order 81, as pronounced upon in plethora of cases, including expire to Orgate, is to the effect that yes, irregularities which are curable will not defeat an action. But there are certain non-compliances which are not irregularities. They are incurable, and then they are nullities. And the expert Orgate, related jurisprudence will tell us that where you have violated the Constitution, you violated the specific legislation, or even the rules of natural justice, as it were, those are matters which go to jurisdiction. And you cannot say that Order 81 will provide a healing balm for you to be remedied so that you continue. No. And what we are talking about, the condition precedent prescribed by a certain legislation, are a part of the things which will not be remedied by Order 81. So let us keep that in mind. So we also started discussion of venue and transfer of proceedings the last time we met. And just before we continue, and we made the point the last time we made that we have only one high court. So we talk about the one high court doctrine. There's only one high court in Ghana, which may sit in various places. And we refer to Article 139 of the Constitution and also Section 14 of the Courts Act. And a number of cases have actually emphasized that. including even like the fast track high court case, the statutory kata cases, and then the Republic and the High Court, expert in another year will be there called the second, and so many other decisions. Now, we also made the point that as far as venue is concerned, it is a matter of administrative convenience. It's not jurisdictional. In other words, the rules on venue are more of administrative convenience than establishing or depriving jurisdiction. So let's keep that in mind. And that is why I invite the class reader to read Order 3, Rule 1 for us.
Good evening, my lord. Good evening, everyone.
Yes.
Order 3, Rule 1, Sub-Rule 1. Every cause or matter that relates to immovable property or any interest in it, or for any damage to it, shall commence in the region in which the immovable property or any part of it is situated. 2. Every cause or matter that relates to movable property, restrained or seized for any cause.
So maybe before you continue to the Order 3, Rule 1, 2, now what Order 3, Rule 1, 1 is telling us is that if you want to sue someone in relation to land, because when you say movable property is land, is nothing other than land. If you want to sue anyone concerning land or landed interests, as it were, the place where you have to mount the action is the region in which the movable property, that is the land, or part of it, is located. So if you want to see someone for declaration of title to land in, let's say, Ho, you don't go to a court in Kumasi or a court in Tamale to do that. You have to go to Ho because that is where the property is situated. So that is what Order 3, Rule 1.1 is telling us. We may also have a situation where the property is located in 2 or 3 regions. Now, where that is the case, the plaintiff has the right of election. You have to elect or choose whether to bring it to, let's say, region A or region B, because it is located in more than one region. So let's keep that in mind. Yes, let's move on to Order 3, Rule 1, 2.
Order 3, Rule 1, 2. Every cause or matter that relates to movable property, restrained or seized for any cause, shall be commenced in the region in which the restraint or seizure takes place.
Good. So you remember your law on sale of goods from commercial law. When we had what we call the rare rights, okay? The rare right of, let's say, the seller or the buyer, as the case may be, including trying to seize or exercise a lien over, let's say, a property, because you think that the other party has breached its obligation under the contract for sale. Now, that is an example of, if you like, a seizure. And the other party may probably disagree that what you've done is wrongful, and he wants to go to court. Or it may just be any other tortious, maybe like any tortious form of a seizure, like trespass to chattels, or as the case may be. So where it is about movable property, maybe your car or anything which has been forcibly taken over by someone, you bring action at the place where the seizure took place. Yes, 3.
3. Every cause or matter against a public officer to recover penalty or forfeiture shall be commenced in the region where the cause of action arises.
Good. So we explained this the last time that if a public officer, for example, has actually violated your right, either maybe wrong surcharge or some other things, and you want to bring an action against the public officer, we are supposed to bring it at the place where the action actually took place. Or let me give an example. Let's suppose that you, let's say that you apply for, let's say, registration of your documents, or even apply for a stamp duty to be paid, and you have been made to pay more than what you are supposed to pay, as it were. So you need to get it recovered. Or you've had your license seized. Well, you have your license seized. You need to bring an action to recover it. It will have to take place at the place where the seizure or the forfeiture, as it were, took place. And then the other three, Rule 1.4, talks about contracts. And then the contract one, I want us to pay attention to it. Yeah, so take us through the other three, Rule 1.4.
Three. 4. Sorry. Every cause or matter of specific performance of a contract or in respect of breach of contract shall be commenced in the region in which the contract ought to have been performed or in which the defendant resides or carries on business.
Good. So when it comes to contract, you notice that we have options. Either you target the place where the contract was supposed to have been performed, or you target the place where the defendant actually resides or carries on business. Now, where the contract was supposed to be performed, then it's pretty straightforward. If it's about payment of money, if it's about payment of money, and let's say that you've not indicated a particular place, but let's say that you've indicated a bank, okay? Now, unless you have specified that payment should be made to, let's say, that the Standard Chartered Bank at the Harper Road. Charles is here, that's why I'm using that. Charles, are you in the class? Okay, good. Where you, for example, have specified that, then it is only that place. But if we just say that payment should be made into your bank account, these banks are network. So whether it's in Accra High Street or Harper Road or Tamale Central, it's essentially the same. But it's different, where maybe like delivery of maybe goods are supposed to be done at a particular place. Maybe goods are supposed to be delivered at Takoradi Port. Then that is a place of performance. So where there is a breach, you can sue at the place of expected performance. Or you can also sue at the place where the defendant resides. So where the defendant resides here, we are talking about not necessarily fleeting presence, but where the defendant resides, as in is a more or less a fixed habitation. Of course, not necessarily in terms of the rules on domicile, as you know, under the conflict of laws, but some form of like a permanency of where the defendant is based, or where the defendant carries on business. So where the defendant carries on business. So for example, if it is a company will have two things. A company will have like the registered place, and then it will have like the business where it runs or carries out its business. So in terms of Order 3, Rule 1, 4, you can decide to use any of those places as a venue for suing. Now let's look at the, yes.
Sorry, with respect, I'm struggling to locate my hand, the hand for question. So I'm sorry.
Oh, okay, no problem. Yeah, let's hear you.
Yes, so this is Edward. So my lord, in terms of Order 3, Rule 1, Sub Rule 3,
yes,
in terms of capacity, do you sue the public officer personally, or you sue the institution for which he works for, and then maybe you add him also? I just want to be clear.
Okay, good. So it will depend upon the actual configuration of facts. In some cases, it will just be just the institution, or even sometimes the Attorney General, because the Attorney General is the nominal defendant in terms of Article 88. Except that for some legislation, like the district assemblies and some other institutions, the Enabling Act or the legislation which set up those institutions who says that it has the capacity to sue and be sued and so on. So where that is the case, then you don't necessarily saddle the Attorney General. You can just go after the institution itself. But in some cases, if you say like the public officer, of course, is relative. So let's say that the Office of Special Prosecutor, okay, or let's say that the YOCO, let's assume that they have confiscated or they have illegally, quote and unquote, in the sense that like it's not the court which has actually sanctioned the freezing of your property and you want to actually recover that. So you definitely target the institution. But you take YOCO, for example, under the law is the executive officer, if you like, the executive officer or like the director, who is the person to be sued and sued. That is particular to that particular law. So it very much depends upon what is at stake. But I understand the wisdom of your question that if we have the institution there, why will you target a particular officer, as it were? Yes. Yeah, so let's look at the 5, the omnibus situation, the general, all other cases. Yes, let's look at the 5.
5. All other causes or matters shall be commenced in the region in which the defendant resides or carries on business.
Good. So in terms of Order 3, Rule 1.5, we are talking about all other situations, that is, all other cases in which we don't have specific rules applying. That is to say that the case you have is not about landed or movable property, in which case the region of its location will be like the venue. And it's not about trying to recover movable property which has been seized or the strain carried out in respect of it, in which case it will have to be done at the place where the seizure took place. Or it's not about you trying to get specific performance or sue for breach of contract, in which case the place of performance will be like the venue. So any case which cannot be subsumed under any of the 4 scenarios or the 4 categories which we have looked at so far will have to come under Order 3, Rule 5. And that is why I say that all other cases or matters, so all other cases other than the ones that we have been discussing, then it will have to be at the place where the defendant resides. So let us keep that in mind. Now let's look at the 6th.
6. If there are 2 or more defendants resident in different regions, the cause or matter may be commenced in any of the regions.
Good. So where, of course, the rule says where the defendant resides, but here's the case: you have 2, 3, 5, 10 defendants, and they're all living in different places. In that case, you have an option where you want to sue. But I know sometimes some people, they want to create, make life unpleasant for their neighbor. Now, I remember when I was a practitioner, some people, they sue, and sometimes they just want to prove a point to the defendant, just to sort of punish the defendant. And he would like the suit to be mounted at a location which will cause inconvenience to the defendant. And that really became the case. Let's say in a region where the high court located all around. So let's say that in Accra, for example, we have high court at the Wija. I think the Wija is part of a greater Accra or central region. Is Wija greater Accra or central region?
Greater Accra.
Okay, good.
Greater Accra, my lord.
All right, good. Yeah, so let's suppose that you have a case against someone, and the person is, let's say, at the Pram Pram, and Pram Pram is also part of Greater Accra. And the land is even situated at Pram Pram. Maybe if you get like a troublesome litigant who wants to punish you, the defendant, he will go and sue you at the High Court at the Wija. And it's still part of the region in which the property is located. And you just have to travel all the time from Pram Pram to Wija. If the no litigation is not a good thing, so if the other one wants to teach you a lesson, he will take you through all those inconveniences to let you suffer a pepper, as the ladies will say it. But the point to note is that where the action has been commenced in a wrong venue, let's suppose that you did not follow the rules in terms of Order 3, Rule 1, all the various scenarios we look at, the 4 scenarios, and then like the general even the scenarios. Let's suppose that the 4 scenarios, one of them is applicable. So the property is located in a particular location. It's located in Pram Pram. But you decide to go and sue the person in the Koforidua High Court. Koforidua is a part of Eastern region. It's not part of Greater Accra. So you have sued in a wrong venue, as it were. Wrong venue or wrong forum, quote unquote. Yeah. Now, that per se does not nullify the proceedings. So where you have sued in a wrong venue, it does not nullify the proceeding. The preparatory authorities to that. So you read Volden against Ghana Goldfields Limited when you get to a list. Then General Portfolio Limited against GNPC. Now where you have actually sued in the wrong forum or the wrong venue, it does not render the proceedings nullity. Because we have already stated at the very beginning that the venue is a matter of administrative convenience and is not a jurisdictional matter. So therefore, if you sued in the wrong venue, it doesn't deprive the court of jurisdiction, except that you've created administrative inconvenience, which the rules are provided an antidote for remedying or correcting same. So let's take note of that. And for that matter, I would like our reader to look at Order 3, Rule 2.
Order 3, Rule 2, Transfer of Proceedings. Sub-Rule 1. Where a cause or matter is commenced in a region other than that in which it ought to have been commenced under Rule 1, it may continue in the region in which it was commenced, unless a. The defendant raises an objection to the jurisdiction before or at the time of the defendant is required to file a defense in the proceedings, or b. The court reports to the Chief Justice that, in its opinion, the proceedings ought to be transferred, and the Chief Justice orders the transfer.
Yes, add the sub-rule 2.
Sub-Rule 2. No proceedings taken prior to an objection to the jurisdiction with regard to venue raised by the defendant by the defendant under paragraph A of Sub-Rule 1 of this rule shall be affected by the objection. But the court, if satisfied that the objection is well-founded, shall inform the Chief Justice that, in its opinion, the cause or matter ought to be transferred to the region in which it ought to have commenced, and the Chief Justice may, upon that, make such order as the Chief Justice considers appropriate.
All right, good. Now, Order 3, Rule 2 is reinforcing the point that venue is for administrative convenience and is not a jurisdictional matter. And for that reason, where you have filed your writ or you have commenced the action in a region other than, in the wrong region, let me put it, in a wrong region in the sense that you did not follow any of the applicable scenarios under Order 3, Rule 1. And let's say that Order 5 even, let's say, does not even apply. Or if it applies, you did not also follow it properly. So you have sealed or commenced the action in a wrong region. Now, Order 3, Rule 2 is telling us that that does not invalidate the action. The action is still valid. A number of scenarios, the defendant may raise an objection to that and say that you have sinned against the rules of venue. So this action ought not to be commenced and conducted in this venue. Now, the defendant may do that, or the court so motu. The court so motu, that is, the judge can just look at it and say that, but if I look at the endorsement and I read your endorsement of your statement of the nature of the statement of claim, that is your relief, and I read your statement of claim itself, it's quite clear that you have sued in the wrong venue, and the venue ought to have been, let's say, Rioso. As in the western north or something region or northern west. Good. So I am going to bring this to the attention of Chief Justice so that the remedial action will be done. So where the defendant has raised the objection, or the court so motu, that is the court on its own, has raised up the issue, it will have to be brought to the attention of the Chief Justice so that the Chief Justice will have to make the order of transfer for it to be taken to the right venue where it ought to have been taken. And I would like you to look at Section 104 of the Courts Act. Can you read Section 104 of the Courts Act for us? Section 104. Don't tell me you don't have it. I've told you you should always have it as well. Section 104 of the Courts Act. Or anybody who has it. Anybody who has it can read it for us.
My lord, please the section again.
104 of the Courts Act. Not the CR for December, the course at this time.
Yes. A judge of the High Court. A judge of the High Court may either on his own motion or on the
No,
application.
please. I mean section 104.
104.
Of the course at not yet, the course at 104.
Power to transfer by the Chief Justice. Subject to the provisions of the Constitution, the Chief Justice may, by order under his hand, transfer a case at any stage of the proceedings from any judge or magistrate to any other judge or magistrate, and from one court to another court of competent jurisdiction, at any time or stage of the proceedings, and either with or without an application from any of the parties to the proceedings, as amended by the Court Amendment, Act 2002 at 620.
All right, continue.
2. The order may be general or special and shall state the nature and extent of the transfer, and in any case of urgency, the power of transfer may be exercised by means of a telegraph, telephonic, or electronic communication from the Chief Justice. 3. A transfer of a case made by telegraph, telephone, or electronic communication and not confirmed immediately by order signed and sealed in a manner specified by the Chief Justice or any other person authorizing that in that behalf by him shall be of no effect.
Good. Yeah, so the takeaway from Order 3 Route 2 read with Section 104 of the Courts Act at 459 as amended is that where a matter has been commenced in a wrong venue, it is not invalid. It will have to be stayed and brought to the attention of the Chief Justice. And then the Chief Justice will make the order for transfer to the appropriate venue. Mind you, the registrar of the court does not have the power to transfer a case. It is only the Chief Justice who can do that. So it's only the Chief Justice who can do that. And that is why now it's even become more flexible that the Chief Justice can exercise this power with the dispatch, with the requisite speed. Now we have a text message, you have a WhatsApp, and all do that. You can just say, okay, the case at the Adenta High Court B should be transferred to Wager Court 4, High Court 4. WhatsApp is sent, and then maybe within 24 hours or so, a letter with the order of the Chief Justice is sent. So this can be done quickly. And then again, we are told that in terms of Order 3, Route 2, Sub-Route 2, where no proceedings or orders have been made by the court prior to the objection or prior to the transfer being made by the Chief Justice, it will not affect, the transfer will not affect validity of any prior proceedings or any prior order. So everything done still remains valid. So please look at cases like Oil and Fats Company Limited against Hooper, 1992 1JLR 326. You have it in your list, which will be sent to you after this class. Then Wilmot and Wilmot, they all reflect the fact that, yes, where action has been commenced in the wrong venue, it can be transferred and it has to be done by the Chief Justice and not a registrar. So let's keep that in mind. Of course, there's a good reason for reserving that power to the Chief Justice, because if registrars could actually do that, you can imagine the abuse which will occur. We have this situation of what they call the forum shopping. In those of you who do private, international, or conflict of laws, you know what they call the forum shopping, where court users or litigants will be looking around for their favorite court or their favorite judges. Excuse me. So that they are assured of a certain favorable determination or management of their case. So that is not good. That is why the lawmaker says that it is the Chief Justice who has the power to actually make such transfer. So let's keep that in mind. And then I have about 40 cases which have been listed with the statement of proposition for you. So when you get the news outline and then the list of cases, make sure that you read them. The way the law is, you understand it better by reading the cases as well. So before we move on to parties and then joinder of course of action,
my lord.
Before we leave here, if you have any question, let me know. Then we start the next topic now. Yes.
My lord.
Please go ahead.
Yeah, thank you. So with respect, there was a case in Takrady,
okay,
where the plaintiff, let me say a petitioner in a divorce matter, had gone to the district court. She went without a lawyer, and the counsel for the respondent raised an objection as to the venue, and the prayer of the counsel was for the case to be transferred to the right venue or forum. Now, the court, instead of making that order, dismissed the action. So I just want to know whether that the action of the court, decision of the court was appropriate.
Okay. Please, what's your name?
This is Edward, my lord.
All right, Edward. Okay, good. Edward, thank you. I think, as far as I understand the law, if we look at the Matrimonial Causes Act, I think when it comes to divorce, is the High Court and the Circuit Court. It's the High Court and then the Circuit Court. And I am not, I don't think in terms of making like divorce orders, unless maybe it's like a customary marriage as it were. I don't know the details of the particular case you're talking about, but I would like you to think that the court did not stay it. Probably, I mean, to start with, it was there are two things. Let's suppose that, let's take Article 33 of the Constitution, okay, when it comes to enforcement of human rights, it's a High Court. So instead of going to the High Court, you go to, let's say, the District Court, or you go to the Circuit Court. The District Court or the Circuit Court does not have jurisdiction with respect to, let's say, the particular type of case that you wanted. So it will not be a matter of staying it and asking the Chief Justice to transfer. No. So let's get the distinction. The transfer contemplated by Section 104 of the Courts Act, and also contemplated by Order 3 Rule 2 of the High Court Procedure Rule CI 47, is talking about where the jurisdiction of the court is properly invoked, except that the rules on administrative convenience in terms of like the venue have been violated. Then we say that there is nothing wrong. We are going to move it to the right venue. And mind you, we have said that the High Court is what? Is one. There's only one High Court. So the particular matter you are bringing, have you properly invoked the jurisdiction of the court? If yes, but then you are dealt in the wrong venue, the transfer can be done. But if the jurisdiction of the court has not properly been invoked, the Chief Justice cannot transfer it from the court, which did not have jurisdiction, to a court which has jurisdiction. No. And despite the fact that the Chief Justice is the overall boss of the judiciary and is given this power by the Constitution, the Chief Justice cannot make a transfer order in respect of a case commenced in a court which does not have jurisdiction for the case to be transferred to the court that has jurisdiction. No, it doesn't work that way, as far as I understand the law. Okay, my friend, Edward.
Thank you, my lord.
Very
That's
well.
good.
Good. Mighty Y Apasu, your hand is up.
Yeah, my lord.
Good.
My question concerns the use of region in Order 3.
Okay.
I want to ask, in light of Order 1, Rule 1, Sub Rule 2, if region will not be interpreted to mean the area of the court and not necessarily administrative region. For example, like the example you made, and even if, for example, a land should be in whole, and the plaintiff begins an action in, say, Sogakope High Court, wouldn't that amount to forum shopping, and wouldn't that create the situation of unnecessary expenses?
So let's say that the land is in a whole. Is that the case?
Yeah.
And then you go to Sogakope High Court instead of whole.
Yes.
Good. Good. So yes, I appreciate the logic of you using the philosophy of the rules Order 1. Yes. If let's say the house you are litigating is in the whole, and then the defendant even resides in, let's say, whole, it does not reside in Sogakope, and then you go and sue in Sogakope, despite the fact that it's in the same region, nothing prevents the defendant from bringing an application to the court to raise an objection and say that in terms of the location of the court vis-a-vis the property and all things pointing to maybe witnesses and everything, they are all in whole. So in order not to defeat the purpose of the rules that are supposed to be interpreted and applied in a way which avoid unnecessary expenses and so on and so forth, the court should stay the matter in in Sogakope, and the Chief Justice attention be drawn to that so that it can be transferred to the court in whole. Yes, so I agree that is possible. And mind you, it's all a question of interpretation. And that is why Order 1 is important. But we cannot make general rules. It will depend upon the facts of the case. So like this facts I gave, the house, let's say at whole, and then you can say that if you look at the pleadings and everything, all the necessary witnesses and all that, they are all within whole. So it is convenient for it to be pursued in whole than in Sogakope. So you have to transport witnesses from whole to Sogakope. The defendant is not resident in Sogakope. The property is not in Sogakope. Yeah. Yeah, so I agree with you. Yes. Okay, Banley, Conlan, we have to hurry up because we have so many things covered. Yes, Banley. And then after that, Gates.
Okay, good evening, my lord.
Good evening.
Yes, please. As you did indicate, when a party to the suit makes an objection to the venue, the presiding or the court is supposed to take note and then maybe either this make a report to the Chief Justice for the case to be remitted or to determine if there's a merit to remit the case. But if the judge or the court on itself or by its own motion decide to
Okay, Bal, are you there? I think he has a network challenge.
Chief Justice,
Yeah.
can the court continue to determine the merits of the case?
I think there was a bit of like a break from your end. But what
Sorry,
I heard
so I was saying
yeah.
that if the court itself makes a determination that they will have to issue a report to the Chief Justice to determine the appropriate venue for the case, and without hearing from the Chief,
without hearing from the Chief Justice, the court goes ahead to determine the case.
will
What
that
would be the
be
legal
something
effect?
that can stand in law?
Okay, good. Yeah, so once then that if the court has made a referral to the Chief Justice, let's suppose that if the party objected and you have determined it, there's a merit and you've made the report to the Chief Justice, you have to wait for the Chief Justice to bring the order. Or if the party did not object, but the court so motu on its own motion decided to look into it and convince itself that yes, this is a case which is in the wrong forum. So let's notify the Chief Justice for the necessary transfer to be done. And then the court is not hearing from the Chief Justice, the court can go ahead. If the court goes ahead, later on, it could become a candidate for judicial review. It could become a candidate for the judicial review. Because if the court is convinced that the venue is wrong, why is it convinced that the venue is wrong? So what has changed? So why don't you wait for the Chief Justice? Yeah, okay. So let's take gifts.
My Lord, with respect, if after the defendant has filed his defense, is he barred from objecting again?
Okay, good. So if we look at the Order 3, Rule 2, which she read for us, especially Order 3, Rule 2, 1A, the defendant raises an objection to the jurisdiction before or at the time the defendant is required to file a defense in the proceedings. Now, if you have filed a defense, you have waived your right. If you filed your defense, you have waived your right. And in terms of Order 81, remember where there's an irregularity and having become aware of the irregularity, you subsequently act as if everything is in order. Then there's an implied waiver. And you can no longer, you cannot, as lawyers will say, you cannot approbate and what? And reprobate. You cannot eat your cake and have it. And that is why the rule has given the contingency that you can raise the objection before you file your defense, or at the time you are required to file a defense in the proceedings. Or you can simply, unless in your defense you've stated that, you can make it as part of your defense that yes, the action is in the wrong venue. So because you have stated it in the defense, you have raised objection. Because you can raise objection when you enter conditional appearance. Come and talk about appearance. Conditional appearance, and then you bring it up. Or at the time of having to file a defense, you can bring it up. So you can enter appearance, but just before you file defense. Because you enter appearance 8 days after being served with the writ. And then you have 14 days to file defense. So the 14 days after entry of appearance is when you are required to file a defense. So before you file a defense, you can object to the venue, and the necessary determination will have to be made. And if there is merit in it, Section 104 of the Code Start to be invoked for the Chief Justice to do the needful. Edward, is your hand up so that we continue? Is your hand up?
Yes, sir, it's up actually, my lord.
Okay, all right.
Yes, and it's a quick clarification. It has to do with the renewal of the writ, and I'll just take it back a little because when you got there, I raised my hand, but I think you didn't see the hand. Now, my clarification, and the clarification I need has to do with the issue of renewal of writs in relation with in instance where there's a statute bar, right, or a statute bars a person. I think you made a particular statement, and I wanted some clarification. Now, let's take the Land Act, for instance, where the period is 12 years. So, assuming I triggered or I filed the rates, let's take like at the 11th year and in the 6th month. So I have 6 months more to go. And then when I filed the writ, it was issued. Now I was unable to serve the writs till 12 months time. So it means that would be more than 12 years because the writ was issued at the 11th year and the 6th month. Now the statement you made, does that imply that because it has entered into the 12th year, I cannot still seek for the renewal of the writ? I just wanted clarification in that regard because I was not clear when you were making that particular statement. So if you can help me that regard.
You had actually gone to court before the limitation period ran out, except that you couldn't get the defendant to be served with the process. Now, because you had gone to court a month or whatever months before the expiry limitation period, even if 12 months for the duration of the writ elapsed, and you've not been able to serve, and you need to go for renewal, it will not be construed as you having had the limitation of action run out and then you want to resurrect it. No, because you had already started before the limitation ran out.
Very well. Thank you very much, my lord.
Very well. Good. So now we move on to parties and joinder of causes of action. So according to the set syllabus by the law school, we are supposed to attain the following at the end of the discussion. Students should be able to identify the different categories of parties in civil proceedings. Students should be able to, they should have the understanding with respect to capacity and the right to take proceedings. And they shouldn't be able to analyze the rules on joinder of causes of action and joinder of parties. Again, a successful student having gone through these sessions should also be able to distinguish misjoinder from non-joinder and understand the procedural consequences. Misjoinder is different from non-joinder. You should understand that. And the fifth, students should be able to understand the representative proceedings and endorsement of capacity. And of course, you should have some familiarity with the key case law. There are a lot of cases. You may not be able to know all of them, but you should know some of the cases for purposes of answering examination question. So we ask, who is a party to a civil action? Who is a party? In other words, who can be part of civil proceedings or civil action? A party is any natural or artificial person. So natural person like you and I, artificial person like corporate soul or corporate aggregate. Who can tell us the difference between a corporate soul and a corporate aggregate? I'm sure company law, you have come across it somehow. Yeah, corporate soul and corporate aggregate. Let me see the hand up. And ladies, I'm not hearing your sweet voices. All the gentlemen have stolen the show tonight. Oh, I think that before I move on, somebody has a question. Based on Barney's question, does the Chief Justice have timelines of reverting to the court? No, the Chief Justice does not have any timeline, but the Chief Justice acts expeditiously. So usually, the Chief Justice will have maybe either the Judicial Secretary or somebody working under him who will be bringing these requests which have come to his desk, to his attention, so that the requisite action can be done. And in fact, there's what we call the supervising high court judges in the various regions, okay? The Chief Justice could be working through them, although they will not be doing this, but they will be like, if you like, an eye and ear for the Chief Justice as far as the particular region is concerned. I hope that answers Don T's questions a little bit. Good. Good. So I come back to my own question. What's the difference between a corporate sole and a corporate aggregate? So look at the chart. Corporate sole and corporate aggregate. Yes, anybody? Are we communicating? Oh. Can you hear me?
Yes, please.
Yes, my lord, we can hear you.
Okay, all right. Edward.
Yes,
my lord.
Yes, let's hear you.
Okay, so the little I know about corporate soul has to do with the kind of the purpose of the company, its values, its culture, or anything that defines the company. That is what I know about being the corporate soul of the company, or the corporate soul. That is what I know. I'm not exactly sure if that suffices, but that is what I know. But when it comes to corporate aggregates,
okay, Edward, I like your yeah. Continue corporate aggregate before I comment.
What I know is when a number of companies are being treated as a single entity, right, for whatever purpose, could be being financial or regulatory purposes. That is what I know when it comes to the corporate aggregate, and then the corporate soul, I know the purpose and then the values that defines the company. That is what I know.
I like your charity in always volunteering to share with us. That is good. But the corporate soul is different, and the corporate aggregate is also different. So let's hear other people. Nelam. Yes, Nelam, let's hear you.
Yes, my lord. My understanding is that the corporate soul is a single individual in an organization, and then the corporate aggregate will be more than one people or multiple of people in the organization.
Okay, good. So, all right. Yeah, I think let's take Elolo. Yes, Elolo. Good. And then Gates.
Yes,
Gates has his hand up. I'm sorry.
okay.
After Elolo, then Gates will speak. Okay.
Yes, my lord. My understanding of a corporate soul could be an individual person who holds a certain office, but that office enjoys some perpetuity. So if that person dies or is no more, the office is filled by another person, but the office is perpetual. but a corporate aggregate is a number of people or different people coming together to form one entity. And within the entity, we have other bodies. So, for example, maybe there's a company that is a conglomerate. So within that conglomerate, you have other companies that are listed within the same conglomerate. So altogether, the company comes under one name, which is that conglomerate. And it also enjoys perpetuity.
All right. Elolo, thank you. I think have you
yes, my lord.
You agree with what your friend said?
Very well, so my lord. Except to add that so the company so has to do with a specific individual who takes responsibility on behalf of the company. So whatever the person does, the company is ratifying the act to be representing the company's interest.
Okay, all right. Thank you. Okay, if you are doing company law, I think usually when I'm doing what they call introduction to company law, in some of my lectures on the YouTube, like the introduction, I usually explain this. And if we read most of the standard books, they also explain that. So as some of you have attempted to point out, the corporate soul actually refers to an office which is occupied by an individual. Like you take a stool, you take the skin, you take like maybe like in the past, like you take like the bishop of a church, ecclesiastical authority, like the Pope, and so on. These are all corporate soul. As soon as one chief dies, we put another chief there. As soon as a pope dies, we go to a process and we select another pope, isn't it? A skin, an occupant dies, the same thing. So, as you rightly said, there's that perpetual succession, but it's just one person. So we say we have so many chiefs. The Gamanche will die, another person will come. As Antony dies, another person will come. Aumafia of Anlo will die, another person will come. The Yana, the same thing, and so on and so forth. But if you are talking about the incorporated company, that is a corporate aggregate. It's not a corporate soul. We will have, persons, having come together and they have been incorporated. And then while they are incorporated, now stand separate from the incorporators, as it were. So just simply, a corporate soul is an office which has a perpetual succession occupied by a person. And a corporate aggregate is an incorporated company, as it were. Yeah, so if you talk about like a party to a suit, it can be a natural person or it can be like an artificial person. An artificial person, it can be a corporate soul. Like head of family, it's a corporate soul. So if the particular opinion dies, it's just the human beings occupying who is dead, but the opinion as an office is there. So let's take note of that. So a party, any natural or artificial person who commences civil proceedings or against whom civil proceedings are commenced. Now, in terms of who the parties are, it depends upon the mode of commencement. So where the action is commenced by writ of summons, the party who initiates is called the plaintiff. And the party defending it or the party against whom it is initiated is called the defendant. Where the mode of commencement is petition, the person who initiates is called the petitioner. And then the person against whom is initiated or who is defending the action is called the respondent. Now, where you have originating motion or notice. The person who commences it is the applicant, and then the person defending it is called the respondent. So let us look at that. And I would like to remind you of Order 2, Rule 1, and then Order 4, Rule 1. So reader, take Order 4, Rule 1 for us.
Order 4, Rule 1. Parties and causes of action. Right to take proceedings. Sub-Rule 1. Subject to these rules, any person may begin and carry on proceedings in person or by a lawyer. A body corporate shall not begin or carry on proceedings except by a lawyer, unless permitted to do so by an express provision of this enactment. 3. A next friend or guardian ad litem of a person with disability shall act by a lawyer.
Good. So, we know that who may sue natural persons may sue personally or through a lawyer. It's not mandatory for you to have a lawyer. You can sue in person, except that common sense will tell you that if your opponent has a lawyer and you are not trained in the law, and you still insist that because the law says that you can sue in person, you are going to do everything by yourself, good luck to you when technicalities start flying. Yeah. But when it comes to artificial person, like companies or institutions, it must sue through a lawyer. Unless we have a law which says that that is not necessary. But I'm not familiar with any law which says that a company should not sue by a lawyer. So the default position of the rule would apply, that it must sue by a lawyer. And again, if you have a person under disability, and when you talk about a person under disability, you are talking about two categories of persons. We are talking of those who, by reason of not attain the age of majority, called minors, or what you call infants, someone below the age of 18, if he is to sue, or if anything proceedings will have to involve, that to have it through the next friend. The next friend. We have a case, a judgment we give on Thursday is still confidential, but when it actually comes out, it's actually a net friend case against the Attorney General and then the IGP. When it comes out later on and it's public, I will share it with you, and then you see another example of what it means to sue by a next friend where a person is a minor. Then we also have persons who are not minors, but they suffer from mental disability. So those persons too, they must actually sue by their guardian ad litem. By their guardian ad litem. And one thing we should know is that the High Court is supposed to be the protector of such persons. So if you look at section 18 and section 19, if you have your course act, please look at section 18 and section 19 for us. Section 18 of the course act and section 19. So yes, 18. You don't have your course act, so when I tell you, now I have to go online and look for it.
Section 18.
All right.
High Court jurisdiction in relation to infants. In addition to any jurisdiction conferred by any enactment, the High Court shall have power subject to the provisions of any other enactment. A. On application by any person and after hearing any objections to the application, to appoint any person as a guardian or as joint guardian for an infant, where the court is of the opinion that the appointment is desirable in the circumstances having regard to the welfare of the infant. B.
Good. So before you continue, we have the Children's Act of 1998 at what? Add the number. At the Children at what?
560.
560. Good. So if you look at the Children's Act, that is the specific legislation or matters pertaining to children. So where there is an inconsistency between the Children's Act and the Cause Act, then by the specialibus, non-generalibus, non-derogate principle, the Children's Act would actually prevail. But where there's no conflict, then they all work hand in hand. So what section 18 of the Cause Act at 459 as amended is telling us is that when it comes to children or minors, the court has the power to appoint guardians or joint guardians to be in charge of the welfare or matters relating to any child, as the case may be. Now let's jump to section 19.
Section 19. High Court jurisdiction in relation to persons of unsound mind. In addition to any jurisdiction conferred by any enactment, the High Court shall have power subject to the provisions of any enactment. A. On application by any person and after hearing any objections to the application, to appoint any person as a guardian or as joint guardian for a person of unsound mind, or to direct the person of unsound mind to be delivered into the care of a responsible authority.
Yes, please jump to the D. Jump to the D.
B. To vary and rescind for good cause an appointment made under
D.
To make such orders as appear necessary or desirable to secure the carrying out of any contract entered into by a person of unsound mind, or the conduct of any legal proceedings in his name or on his behalf.
Good. So, by combined effect of section 18 and section 19 of the Cause Acts, with respect to persons under disability, minors or persons of unsound mind, they cannot sue in their own right. They have to sue through next friend or guardian ad litem, as the case may be. So, for example, if a child has suffered injury, maybe, and you need to bring an action, you have to do so by the guardian ad litem or the next friend, as it were. Now, just before we round up for the night and then we continue on Friday and Saturday, the case of Kous Motors against Checkpoint Ghana Limited reminds us that if you initiate proceedings before capacity is acquired, the action is a nullity and must fail. So before we continue, we must keep in mind that capacity in which a person is bringing the proceeding must exist at the time of commencement and not created retrospectively. So that you don't say that, oh, let me issue the writ and then I will take steps to go and acquire the capacity. No. The capacity must exist at the time that you issue the writ and not after. So let's keep that in mind. Now, just before we go, if you look at Order 4, Rule 1, which we'll be discussing, the rationale or the reason behind that, particularly with respect to the persons under disability, is to protect vulnerable litigants. Protect vulnerable litigants, infants. Otherwise, people will be taking actions or they'll be exploited. And that is why there are special rules protecting them. Now let's move on to Rule 2.
Rule 2, Joinder of causes of action. Sub-Rule 1, subject to Rule 4 of this order, a plaintiff may in one action claim relief against the same defendant in respect of more than one cause of action. A. If the plaintiff claims and the defendant is alleged to be liable in respect of all of the causes of action. B. If the plaintiff claims and the defendant is alleged to be liable in the capacity of executor or administrator of a next or successor under customary law in respect of one or more of the causes of action, and in the defendant's personal capacity, but with reference to the same estate in respect of all the other, or C, in any other case with leave of the court. 2. An application for leave under Sub-Rule 1C shall be made ex parte before the issue of the writ and shall be supported by an affidavit stating the grounds for the application.
Okay. So having read Order 4, Rule 2, first of all, we need to appreciate that the philosophy underlying the rules on Joinder are what we have been reciting all along. Order 1, Rule 2. Just as the rules are supposed to be interpreted and enforced to achieve speedy justice, avoid multiplicity of suits, ensure complete effective determination of disputes. So this is the background against which the various rules on Joinder, be it a Joinder of a cause of action or Joinder of parties, which we are going to be discussing, are actually crafted by the rules of court committee. And the Joinder rules ensure that we avoid a piecemeal litigation. Piecemeal litigation in the sense that if you have a case against me or against us, bring everything to the table and then let me face whatever you have against me, rather than you bring an aspect, then I go through the full cycle with you. Now, just as I finish that, you just start another one. And it's like you and I, we are always in court, just fighting one suit or another, when everything could have been brought in one breath for us to know who is right or who is wrong, or who is entitled to succeed, or who is supposed to fail. So having known that, we need to understand what is the cause of action. Cause of action, what is it? In law of tort, you came across the case known as the case of Litton and Cooper. Litton and Cooper. I know you're forgetting your law of tort, so I'm not going to worry you to tell me about the particular tortious action. Suffice to say that in that case, the court gave a very helpful explanation of what a cause of action is. And students and teachers of civil procedure for many years in various jurisdictions actually adopt that. And if you look at the Black's Law, Law Dictionary, I think in substance, they also adopt that a cause of action is a factual situation giving rise to a legal right to sue. So a factual situation for which the law will provide a remedy. So that is a cause of action. So look at the cases like the Litton and Cooper. Excuse me. So look at the case like the Litton and Cooper, and it will remind us of that. And also Spokesman Publication Limited against the Attorney General. So we ask the fundamental question. When may causes of action be joined by a party? You are the plaintiff. You are going to sue the defendant. Can you lump up together more than one cause of action? Now we have understood a cause of action already as the factual situation for which the law will give a remedy, or the bundle of facts from which the plaintiff derives his right to relief or to remedy, as a spokesman against the Attorney General will tell us. So you, the plaintiff, setting up your case, under what circumstance can you bring multiple causes of action, more than one cause of action, in a single writ of summons, without leave of the court? Now, as she read for us in order 4, Rule 2, 1, a plaintiff may join multiple causes of action in a single writ without leave if the defendant is alleged to be liable in all the causes of action. In other words, let's say that you, the plaintiff, you have 4 or 3 different factual scenarios, by which reason you think that you're entitled to a certain relief or remedy. And you are convinced that that remedy you're entitled to is against the interest of the defendant. If all the remedies you're entitled to in any of the 3 or 4 causes of action you think are against the defendant, then it is permissible for you to lump those various causes of action in a single writ. And you don't need to go to court to get a leave before you can do that. It is still the case, even if the defendant, you have the different causes of action against. The defendant has what they call like a different capacities, okay? One defendant may wear many caps or different capacity. And as we saw from Order 4, Rule 2, 1B, you can have a defendant that you have sued. The person is the executor of a will, okay? At the same time, he may have some other capacity. He may be the customary successor, or he may have his personal capacity. So he's the executor of a particular estate. And in relation to that, he also has like a personal claim. So let's suppose that he's a executor and probably a beneficiary, like that, or some other personal capacity. It's permissible for you to bring multiple or more than one cause of action against a defendant who has different capacities. So let's keep that in mind. Are we clear?
Yes, Lord.
Okay. All right. So I'll take your question and then
hello, sir.
Yes. Bondi.
No, please, respectfully.
I think Charles
Can you?
When you finish, then Charles will come. Prince Charles. Okay.
Yes, please, respectfully, can you repeat the first scenario for clarity?
You mean the joinder?
Yeah, the joinder. You're giving two scenarios where there are multiple, say there are different causes of actions and when there are different capacities here. So the first scenario.
Okay, so the first scenario, that the plaintiff has more than one cause of action against the same defendant. More than one cause of action against the same defendant. Let me give you an illustration. So let's say that the defendant is a tenant. He has defaulted in paying rent. And then the defendant, you also had a contract with the defendant for him. He's a carpenter in your house. He took money to construct an wardrobe for you or some furniture. He's taking the money, but he's not done it. And then let's suppose that this same defendant, he has a motorbike, or let's say, what did they call it? The Okada or Pragya. And then he has run into your new Mercedes-Benz. There's a serious dent. So that is a tortious action, isn't it? Now, these are three scenarios, three factual situations. And by those three scenarios, you are looking for a relief or remedy against this same defendant, this poor carpenter tenant who has also dented your new car. So order 4, row 2, is telling us that you don't need to separate these three actions and bring three separate writ of summons, three separate cases against the same defendant, because it's against the same defendant and you can bring them all together in one writ of summons. So you can lump all these cases together in one writ of summons, and that is what we are talking about. And then we also have the other. So here, even there, you notice we can also have maybe when it comes to estate, we have someone, maybe let's say that someone that intestate, and you are the customer's assessor, and you are also the busuapanyi or the head of family, and you apply for, let's say, letters of administration. You'll be given the LA, and just before you start distributing the estate according to PNDC law 111, maybe somebody brings a probate action against you and order 66, trying to claim that a particular property is, for example, not for the disease, but for him, and then let's say that then the person even challenging that, quite apart from that, if you the one who went for the early, you are not one of those eligible to be given early. And let's suppose that you are also saying that that property, that property you've gotten early, you're probably saying that even it's just 50% of the interest in it, which is for the disease. So the early that you obtain is not only for the estate of the disease, only part of it, because you are also a co-owner. So here, you're wearing many hats. The person who is suing is saying that that property is for him, and that it cannot form part of the estate of the disease. That is one. But the person also get to know that you too, by reason of you having gone for early, in respect of just the 50% interest of the disease, the other 50%, you are claiming it in your personal capacity. So he can lump all those causes of action together. He doesn't have to sue you as a personal representative or administrator of the estate of the disease, and then come and sue you separately in your personal capacity for the other 50%, which you claim is for you. So all those can be lumped together. And here we have a defendant who is having different capacities. So that is what I was trying to elaborate. So let's take a Prince Charles before we wind up for the night. Prince Charles, your hand is up, or is it by mistake? That's probably by mistake. Okay. So thank you very much. We will meet again on Friday. Good night.
My lord.
Yeah.
Good evening, my lord. Please, I would like to know if you will share your recordings, because I've been experiencing some network issues from the beginning. I don't know if
I think they are recording it, so they should be able to share that with you.
Okay, thank you.
I think Margaret, the coordinator, is Margaret. Are you here? Okay, maybe somebody will just.
Please, we'll have the recordings at the end of the class.
Okay. All right. Thank you.
Thank you very much.